So now I'll talk about freedom of speech versus censorship and digital journalism. Freedom of information refers to the right of the individuals to access information held by public authorities. This right is essential for fostering transparency, accountability, and public participation in governance. So, FOI, Freedom of Information laws, empower citizens to request information, enabling them to hold governments or government officials, public authorities accountable and make informed decisions. So, this concept of freedom of information, FOI, as it pertains to global law and practice, it examines the legal framework that support FOI, the varying degrees of implementation across different countries, and the challenges faced in ensuring transparency, accountability, etc. So, by analyzing the principles and practices surrounding FOI, this discussion aims to provide a comprehensive overview of the significance of FOI in promoting democratic governance and protecting citizens' rights. Many countries have enacted specific FOI laws to operationalize the right to access information. So, examples like in the United States, the Freedom of Information Act 1966 allows citizens to request access to federal agency records. Similarly, in Sweden, the Freedom of the Press Act of 1766 is one of the oldest FOI laws, granting citizens the right to access public documents. In India, the Right to Information Act of 2005 empowers citizens to request information from public authorities, promoting transparency. Now, there are different variations in FOI implementation. The implementation of FOI laws varies significantly across the globe. Some countries have robust frameworks and practices, while others face challenges such as limited scope. In some nations, FOI laws may exclude certain types of information or public bodies. Bureaucratic obstacles. So, complex procedures and excessive fees can hinder access to information. Then, political resistance. So, governments, the ruling government, may resist transparency due to concerns over national security or some other political fallout or consequences. So, despite the legal frameworks put in place, several challenges persist in the effective implementation of FOI. The first is the lack of awareness. Citizens may not be aware of their rights under FOI laws, leading to underutilization. Then, inadequate resources. So, public authorities may lack the necessary resources to process all these requests efficiently. Then, retaliation and censorship. In some regions, individuals who seek information from the government may face harassment or other types of persecution. The legal frameworks supporting FOI as the international standards. So several international instruments advocate for the right to information. For example, Universal Declaration of Human Rights, UDHR, which has been declared in 1948. So, Article 19 of UDHR emphasizes the right to seek, receive, and import information. Similarly, International Covenant on Civil and Political Rights, ICCPR, there Article 19 reinforces the right to freedom of expression, which includes the freedom to seek information from public authorities or government. Now, the philosophical thinkers like John Milton, John Locke were eagerly advocating against censorship. All these philosophers advocated fiercely against censorship, linking freedom of expression to the development of democratic governance. This principle was famously reinforced in the First Amendment of the US Constitution, which declares, I quote, Congress shall make no law abridging the freedom of speech or of the press. However, it was only with the creation of the United Nations and the emergence of international human rights law that freedom of expression was globally recognized. So, Article 19 of the 1948 Universal Declaration of Human Rights, UDHR, which also affirms that, I quote, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and import information and ideas through any media and regardless of frontiers. So, this principle was later codified in binding law under Article 19 of the International Covenant on Civil and Political Rights, ICCPO, which affords the same freedom but also outlines legitimate limitations under specific conditions. So, in Europe, the right to freedom of expression received binding legal protection even earlier. The European Convention on Human Rights, ECHR, adopted in 1950 and effective from 1953 onwards, guarantees this right under Article 10, which states, I quote, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authorities and regardless of frontiers. It also permits states to regulate aspects like broadcasting, television, and cinema through licensing. Similar to the ICCPR, Article 10 of the ECHR allows certain restrictions on freedom of expression provided they meet legal, necessary, and proportional criteria. At its first session in 1946, the United Nations General Assembly declared, I quote, freedom of information is a fundamental human right and the touchstone of all the freedoms to which the United Nations is consecrated. In this context, freedom of information is seen as an essential part of freedom of expression, aligning with the phrasing in Article 19 of the UDHR, which says, I quote, the freedom to seek, receive, and import information. The term touchstone is a tool used to test the purity of precious metals, is used metaphorically here to suggest that freedom of expression serves as a measure of how well other rights and freedoms are respected. So, from this perspective, one could argue that freedom of expression holds a foundational status as it enables the exercise and protection of other rights. So, this is the position taken mostly in the United States, where the First Amendment and Supreme Court jurisprudence underscore the centrality and primacy of free expression. However, this view is not widely adopted in Europe or within the United Nations human rights system. For example, the European Court of Human Rights, ECHR, while occasionally citing US precedents, does not treat freedom of expression as above all other rights. So, in practice, freedom of expression is not absolute. It can be restricted in certain or under certain circumstances, such as to safeguard the reputation of others or in times of national emergency. This places it at a lower legal status than absolute rights like freedom of conscience or the prohibition of torture, which are not subject to the same kinds of limitations. Today, nearly all European states except Vatican City, Belarus, and Kazakhstan are parties to ECHR, reinforcing a shared commitment to this fundamental rights. At its very first session in 1946, United Nations General Assembly declared freedom of information is a fundamental human right. Now, I'll discuss the complex and often contentious relationship between freedom of speech and expression and censorship within the realm of digital journalism. So, it examines the core principles of freedom of speech, the various forms of censorship that can manifest online, and the challenges faced by digital journalists in navigating this intricate landscape. Furthermore, I will delve into the ethical considerations and potential consequences of both unrestricted expression and overly restrictive censorship, aiming to provide a balanced perspective on this critical issue in the digital era. So, freedom of speech is a cornerstone of democratic societies, which guarantees individuals the right to express their opinion and ideas without fear of government reprisal or retribution. So, this right is enshrined in numerous national constitutions and international human rights declarations, including the First Amendment of the United States Constitution. The underlying rationale is that the free exchange of ideas, even those considered unpopular or offensive, is essential for informed public discourses, for the pursuit of truth, and the accountability of power, different centers of power. However, freedom of speech is not absolute. Most legal frameworks recognize limitations on this right, particularly when speech incites violence, defamation, or poses a direct threat to public safety. So the challenge lies in defining these limitations precisely and ensuring that they are applied fairly and consistently without unduly restricting legitimate expression.